Threat. That is a threat. You're threatening me under color of law now to take something on private property, which I don't believe you even have the authority to do.
It's a dictionary term, sir.
Okay.
It comes from black laws.
Covering food, you pulled me over for no reason.
I didn't know.
Step back here with us. Give us your information.
He already gave me his information.
I gave him everything you all need. What else do you need?
Let me just talk to you.
Welcome to another episode of U.S. Corrupt Cops, where we expose instances of police misconduct across the nation. In today's segment, we delve into the case of a corrupt officer who unlawfully detains a driver and faces immediate consequences, being removed from duty. If you enjoy this video, press 1. On the morning of April 19, 2023, Officer Scott Harrell of the Texas City Police Department approached driver Christopher Shull at a Buc-ee's gas station pump. He accused Mr. Shull of speeding through parking spaces, allegedly causing a white truck to brake suddenly to avoid a collision. The interaction that followed was captured on Officer Harrell's body camera.
Car, please. Don't walk up to my car, please. Hey, man, you can't drive through a parking lot like that. You got your driver's license insurance? Any weapons in the car I need to worry about?
No, man.
Is there any particular reason why you felt you needed to come through the parking lot like that?
I didn't think I did anything wrong. I just came over to get gas.
You were speeding and you cut through parking spaces. You know you can't do that.
I didn't think I was doing anything, man.
You
all
walked
I'm
around.
doing is coming to get gas.
Yeah. Oh, are we gonna go back and forth, or are you just gonna?
You asked me the question. You want me to answer it or not? I'm not. If anything, I thought I was going even slower than normal.
No, sir.
Normally, people don't even park where you park, and that's the direct path to the gas pumps.
You almost hit that car that was turning right there. I was watching, man. As soon as you cut in front of me like that, I was like looking, and I watched it happen. So
I come here every day. There's almost never, ever anybody. So yeah, I go through there because it's the straight path from the entryway to here, which is what you're going to see everybody else do it. But I mean, I hear you, man. I got it. To you, it looked like I was going fast. To me, I thought I was going even slower than normal because I didn't want to get too close to you.
Thank you. Okay, sit tight for 1 second. You can fill up your car. Go ahead and fill up your car. Okay. So.
I'm not kidding you either, man. I come here every day, dude.
I'm not.
I send pictures of my wife the price of the gas here every day when I come through.
Okay, look, I'm not gonna write you tickets, but the only reason I'm not writing you tickets is because I'm out of tickets right now. Okay, otherwise you would be receiving a citation.
For what? What did the citation? I'm just curious.
Disregarding traffic control device.
On private property?
Yes.
Okay.
You still can't do that. It's still illegal.
Okay.
Officer Harrell mentions that if he hadn't run out of tickets, he would have cited Mr. Shull for disregarding a traffic control device, despite the alleged violation occurring on private property. According to Section 544.004 of the Texas Transportation Code, a driver must comply with an official traffic control device, which Section 541.304 defines as a sign, signal, marking, or device that is consistent with this subtitle, placed or erected by a public body or officer having jurisdiction, and used to regulate, warn, or guide traffic. While parking space lines might be considered markings, it's highly unlikely that they were placed by a public body or officer in a private parking lot. Furthermore, Section 542.001 of the Transportation Code states that a provision of this subtitle relating to the operation of a vehicle applies only to the operation of a vehicle on a highway, unless the provision specifically applies to a different place. Section 541.302 defines highway as the width between the boundary lines of a publicly maintained way, any part of which is open to the public for vehicular travel, meaning that under Texas law, the traffic code generally doesn't apply to private parking lots. Therefore, it's highly improbable that a court would find Mr. Shull's driving constituted disregarding a traffic control device, even if the parking space lines were considered official traffic control devices.
Ticket.
I hear you, man. I understand.
I don't appreciate the attitude. Two, I get it. You're upset. Nobody likes cops pulling up on them. Nobody likes it. Okay, but you know you did wrong. You know you're not supposed to cut through the parking lot. And instead of being like, oh yeah, I messed up. Sorry, it won't happen again. You want to sit here and go back and forth with it.
There's a lot better things than this to be doing for you, man.
You're right. I was working on a report.
You can be over here. There's people right now running 90 miles an hour on the thing.
You want to go to jail?
So
You want to go to jail? You could go to jail for this.
You can do what you want to do. I can't stop.
I don't want to take you to jail.
You know?
That is definitely a waste of my time. Okay, but the attitude is not necessary.
I agree.
That's on your part, sir. I haven't been rude to you at all. I will get in trouble. You go file a complaint, get me in trouble, write me up.
Yeah, I'm not worried about that.
All right, well, I'll make sure that I'm there all the time. If I see it happen again, then we'll go from there, okay?
Okay.
All right?
I'll look that law up on private property too. I don't believe you'd have the authority to do anything here on this parking lot like that.
I could also take you to jail for Class B reckless driving because you did almost hit that car.
I didn't almost hit anybody. I was nowhere near. There's cameras everywhere.
Officer Harrell claims he could take Mr. Shull to jail for Class A reckless driving because he almost hit another vehicle. Section 545.401 of the Texas Transportation Code defines the offense of reckless driving as a Class A misdemeanor and states that this section applies to a private parking area provided for a client or patron by a business other than a private residential property or the property of a garage or parking lot for which a charge is made for the storing or parking of motor vehicles, notwithstanding Section 542.001, which limits the application of traffic infractions to public highways, unless the provision specifically applies to a different place. Therefore, unlike the statute prohibiting disregarding a traffic control device, the reckless driving statute would apply in the Buc-ee's parking lot. The statute says that a person commits an offense if the person drives a vehicle in willful or wanton disregard for the safety of persons or property. In the 2011 case of Franklin v. State, the 5th District Court of Appeals of Texas explained that willful and wanton disregard means the deliberate and conscious indifference to the safety of others. In Franklin, the court determined that an officer had reasonable suspicion to stop an individual for reckless driving after observing him driving through a Shell station parking lot at a high rate of speed, causing the vehicle's tires to squeal. Although Officer Harrell and Mr. Shull disagreed about the speed at which Mr. Shull was driving and whether he almost hit another vehicle, based on this precedent, it's possible that a court could conclude that Officer Harrell had at least reasonable suspicion to stop Mr. Shull for reckless driving if the evidence supported Officer Harrell's version of events.
You can do what you want to do, Harold. I can't stop you. If you want to be this way, then that's up to you. I'm trying to be a reasonable person.
Are you having a bad day, sir? Is there a reason why you're acting like
I'm
this?
having a bad day because you're
voice
doing
to you
this
at
to
all?
me. I think this whole thing is ridiculous.
What do you specifically think is ridiculous?
That we're even talking about nothing happened, and here we are talking, and you're threatening to take me to jail.
No, I'm
and
just
so I
advising you
shouldn't be
that
getting
it's
upset.
I don't call it a threat, sir.
No, it's a threat. That is a threat. You're threatening me under color of law now to take something on private property, which I don't believe you even have the authority to do.
It's a dictionary term, sir.
Okay.
It comes from black laws.
No, it's not. It's a Class A
Dictionary.
misdemeanor for you to threaten or arrest me over something that you know is not really true. But that's okay.
What's the penal code on that, sir?
Mr. Shull asserts it is a Class A misdemeanor for Officer Harrell to threaten to arrest him over something he knows to be untrue. It appears that Mr. Shull is referring to Section 39.03 of the Texas Penal Code, which outlines the offense of official oppression, a Class A misdemeanor. Under this statute, a public servant acting under color of his office or employment commits an offense if he intentionally subjects another to mistreatment or to arrest, detention, search, seizure, dispossession, assessment, or lien that he knows is unlawful. According to Section 1.07 of the Texas Penal Code, unlawful means criminal or tortious conduct. In the 1996 case of State v. Edmond, the Court of Criminal Appeals of Texas held that a public servant can only be charged under this statute for mistreatment that is either criminal or tortious, meaning that an officer cannot violate this statute by committing mistreatment that is otherwise legal. As the 3rd District Court of Appeals of Texas explained in the 2020 case of Ratliff v. State, it can be inferred that public servants know their conduct is unlawful based on their actions and remarks, as well as the circumstances surrounding their actions. Evidence regarding a police officer's training can be considered when determining whether they are guilty of official oppression in circumstances where a statutory provision clearly prohibits their conduct. Applying this case law, if a court concluded that Officer Harrell illegally arrested or detained Mr. Shull, he could potentially be convicted of violating the statute, although it may be challenging for the government to prove that he knew his conduct was unlawful.
That's okay.
Trust
okay.
you.
Okay, we're good.
I don't feel like we are. I feel like this is this is a problem.
How is it a problem?
I feel like you're going to continue to commit these behaviors that are unsafe and put people at risk.
So
you don't feel like you did anything wrong.
Something that's possible they may do in the future. So now we're playing Jean-Claude Van Damme future cop, and you need to stop me from something I may do in the future. That's now your position.
What is the law designed to do, sir?
Oh, I know you want
designed
compliance.
to stop people from doing things that they're not
voluntary
supposed
compliance.
to be doing.
I know you want voluntary compliance.
Okay, go ahead and put your hands on your back.
Wow. That's an injury on my left arm.
Well, I mean, I don't. Would you like 2 sets of handcuffs?
No, my head hurts. Cannot believe you're doing this.
Well, sir, I'm concerned that you're going to continue to do this unsafe behavior. So it didn't have to go this way.
No, it never did. None of this ever needed to happen, I don't believe.
Okay, well, I disagree with you.
Okay, I know.
I mean, you wanted to sit here and argue with me about what I observed with my own eyes.
I didn't think I was supposed
you
to
didn't
hit
hit
no, you're talking about the white truck.
Vehicle. Yes, you even know what truck I was talking about.
Yeah.
Okay, so what are we gonna do about the car?
I didn't think I was going that far.
You certainly were, sir. You definitely were.
Can we back this down, dude? Can we cool off here, please? I'm sorry. I will.
You have forced my hand at this point.
will.
Because if I don't go and see this through to its conclusion, I know you're going to go to the police department and file a complaint on me. Now, the complaint's not going to do anything because I have it all on video. Everything is recorded. I don't talk to anyone in the public unless I have my camera on.
Officer Harrell tells Mr. Shull that he arrested him because he thinks he's going to file a complaint against him. And earlier in the interaction, he stated that he arrested him because he argued with him about his driving behavior and the legality of his conduct. As the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, explained in the 2021 case of Oliver v. Arnold, a government official violates the First Amendment by retaliating against a person for exercising First Amendment rights. That is, by taking adverse actions that cause the plaintiff an injury that would chill a person of ordinary firmness from continuing to engage in that protected activity. Similarly, in the 2019 case of Neves v. Bartlett, the Supreme Court stated that it is not enough to show that an official acted with a retaliatory motive and that the plaintiff was injured. The motive must cause the injury and the but-for cause, meaning that the adverse action against the plaintiff would not have been taken absent the retaliatory motive. Despite this recognition, the court ultimately concluded in Neves that probable cause speaks to the objective reasonableness of an arrest in First Amendment claims involving a potentially retaliatory arrest. The presence of probable cause should generally defeat a First Amendment retaliatory arrest claim, although the court recognized that a narrow qualification is warranted for circumstances where officers have probable cause to make arrests, but typically exercise their discretion not to do so. It's not enough for a plaintiff in these circumstances to show that the officer chose to arrest them because of their speech after originally exercising their discretion to issue a citation, as Officer Harrell did here. Rather, the court concluded that the no probable cause requirement should not apply when a plaintiff presents objective evidence that he was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. When applying this precedent, it's important to keep in mind that, as the Supreme Court noted in the 2018 case of District of Columbia v. Wesby, because probable cause is an objective standard, an arrest is lawful if the officer had probable cause to arrest for any offense, not just the offense cited at the time of arrest or booking. Accordingly, if a court determined that Officer Harrell had probable cause to arrest Mr. Shull for reckless driving, it is highly likely that it would also reject any First Amendment retaliatory arrest claims against Officer Harrell, even though he essentially admitted to arresting Mr. Shull for his speech and told Mr. Shull that he was under arrest for disregarding a traffic control device, an offense for which he clearly did not have probable cause.
I'm not gonna go complain to Harrell at all. I'm just a little upset because I really, honestly...
Sir, I watched it happen, but I explained it to you and then you wanted to argue with me. And he came through the parking lot and cut through all the spaces. He came through so fast and whooped into here, and there was a white truck. The white truck had to slam on its brakes. So I come over here. I was just gonna be like, hey man,
Chill out.
Like, chill out, don't be like that. But he wanted to go back and forth and argue with me and give me all kinds of stuff. I didn't have any tickets and I didn't grab a rider this morning, so I was like, man, look, it doesn't have to go this way. He kept going back and forth, so I was like, all right, let's go. You have a rider?
I got paper tickets.
You got paper tickets? That's what I'd rather do.
Okay.
Okay, I'm gonna do this a different way. So the other officer has a ticket book he's gonna let me use. You're gonna be receiving the citation, okay? Because I think going to jail is a bit excessive. But, well, I agree with you, but I didn't have another option. I don't have another ticket book and I don't have a ticket writer with me. So we're gonna do it that way, okay? Step out for me.
It presses that scar and then it hurts.
Okay, I see you sign right here. It's not a mission of guilt.
Repeat your last?
Mr. Shull is no longer in custody. Free to go, sir.
After Mr. Shull was cited and released, he obtained the body camera footage and posted it to his YouTube channel on May 15th, 2023, and it was shared on several other channels. In response to the backlash from the video, Texas City Police Chief Joe Stanton released a statement on May 24th, informing the public that he had ordered an internal investigation into Officer Harrell's conduct by the Office of Professional Standards, and that the investigation could lead to possible criminal charges. Chief Stanton also reported that Officer Harrell had been placed on inside administrative duties pending the outcome of the investigation, and stated that the Texas City Police Department has strict policies prohibiting officers from violating individuals' rights with whom the officers encounter. These strict policies are underscored in the city's and the Texas City Police Department's policies, training, and practices. Mr. Shull reported to the Law and Crime Network YouTube channel that he received a letter in the mail on May 26th informing him that his citation had been dismissed. He also indicated in the comments of his YouTube video that he is pursuing civil action against the department, and he has set up both a GoFundMe campaign and a Give, Send, Go campaign to assist with legal fees. As of the date of writing this episode, the Buc-ee's surveillance footage showing Mr. Shull's driving has not been released to the public. Overall, Officer Harrell receives an F for demonstrating a fundamental misunderstanding of Texas traffic laws, potentially exceeding his legal authority as a police officer, and arresting Mr. Shull for disagreeing with him about his driving behavior and the legality of his conduct, although it will remain uncertain whether Officer Harrell had reasonable suspicion or probable cause to detain or arrest Mr. Shull for reckless driving until the surveillance footage becomes publicly available. It is undeniable that Mr. Shull did not commit the offense of disregarding a traffic control device, which is the violation that Officer Harrell explicitly stated he detained, arrested, and cited Mr. Shull for. While it is possible that a court could reject a First Amendment claim against Officer Harrell if it found probable cause existed for a reckless driving arrest, that does not change the fact that Officer Harrell seemingly admitted to Mr. Shull that he was arresting him both because of his speech and to prevent him from filing a complaint. This encounter demonstrates how Supreme Court precedent limits the ability of individuals with legitimate First Amendment retaliatory arrest claims to pursue justice. Because of cases like these, I find myself agreeing with Justice Sonia Sotomayor's dissenting opinion in Neves v. Bartlett, in which she argued that, while probable cause has undeniable evidentiary significance to the underlying question of what motivated an arrest, some arrests are demonstrably retaliation for protected speech notwithstanding probable cause of some coincidental infraction, and that plaintiffs should have a meaningful opportunity to prove such claims when they arise. Mr. Shull earns an A+ for respectfully voicing his dissent to Officer Harrell's actions, complying with the officer's orders even though he disagreed with them, and taking steps to challenge the officer's conduct by pursuing legal action. All too often on this channel, we review encounters where citizens resist officers' attempts to arrest them because they do not believe they should be arrested, which in many states is a crime regardless of whether or not the arrest was lawful. In this situation, I commend Mr. Shull for immediately complying with Officer Harrell's attempts to arrest him while verbally voicing his disagreement with his decisions and attempting to de-escalate the situation, and then challenging the officer's actions after the completion of the encounter. Although he may have a difficult legal battle ahead of him, I would encourage Mr. Shull to press on in his pursuit of a civil lawsuit. Next, in October 2022, 2 officers from the Charleston Police Department observed a vehicle dropping something off at a house in a local neighborhood around West Virginia. Suspecting that something suspicious might be happening, they decided to watch the vehicle. During this time, they noticed that the vehicle had a broken tag light, which gave them a reason to initiate a traffic stop immediately. We will discuss whether this was a lawful reason in just a moment. The driver, Mr. Jordan, began recording the encounter on his smartphone as soon as he was pulled over. Shortly after, one of the officers approached Mr. Jordan's vehicle and immediately ordered him to step out without explaining the nature or reason for the traffic stop. Mr. Jordan promptly asked why he needed to step out, and the officer responded that he has the authority to ask anyone to step out during any traffic stop, adding that it was a lawful order and that Mr. Jordan must comply.
Hey, go ahead and step out for me, brother.
What?
Because I'm asking you to.
I didn't break any laws. I didn't break any laws.
I understand that, and I'm recording you too, but I'm asking you to step out. Step out.
I haven't broke any laws. I'm not
I
under
can
arrest.
ask anybody to step out on any traffic stop.
No, you
It's a
can't.
lawful
No, you
order.
cannot.
Yes,
I didn't break any law.
I'm asking you to step out.
I'm going to call my attorney.
Okay.
This is unlawful. What'd you even stop me for?
Your registration light's out. You have a registration light out. So, partner, go ahead and step out for me.
To determine whether the traffic stop itself was lawful, we can refer to Chapter 17C of the West Virginia Code, which states that either a tail lamp or a separate lamp shall be so constructed and placed that it illuminates with white light the rear registration plate and renders it clearly legible from a distance of 50 feet to the rear. Considering this, it could be debated whether the vehicle's rear registration plate was clearly visible from 50 feet or not. If it was not, then this traffic stop might be lawful from the outset. If it was, then the officers may not have had a valid reason to pull Mr. Jordan over. It's also noteworthy that only one of the vehicle's tag lights was broken, and it's very possible that the remaining tag light illuminated the rear registration plate sufficiently to be seen from beyond 50 feet. Regardless, the second officer also approached Mr. Jordan, who made the same claims, stating that the officer had the authority to pull Mr. Jordan out just because they said so. One of the officers also added that he wanted Mr. Jordan to step out so they could have a word with him. However, there was more to it. The officer's actions raised concerns, but they didn't stop there and made an attempt to intimidate Mr. Jordan. They threatened to charge him with obstruction of justice, which only added to the already tense situation, and suggested that the officers might not be acting in good faith.
Am I under arrest?
You're not under arrest.
What's going on today?
Nothing's under. I'm trying to deliver my food here.
I understand.
Okay, so
I've got a lawsuit against the state police right now, and this is gonna be documented. I'm just letting you know.
it's documented right here too.
Okay. Well, they
So
didn't
listen to
document
me,
when
man.
they beat
He
me.
made a lawful traffic stop on you because you got a registration
Okay.
light out.
And I'm just asking you to step
So-
out so I can talk to you.
To conduct his investigation,
I'm not getting out of the car. I didn't do
stop,
nothing wrong.
You have to exit the vehicle when he's giving you a lawful order. So if you come out of the vehicle,
If you arrest me, then if I'm under arrest, then I have to get out. But if I'm not under arrest, I'm not getting out of the
no,
car.
listen, but if you refuse to get out and we have to pull you out, then you will get arrested.
You can't pull me out of the car if I'm not arrested.
We can't because I'm asking you to on a
I know
listen,
you
man.
see all these
I'm trying
videos on
to
TV
work
all
with
the
you,
time.
buddy. I'm trying to work.
You're trying to work with me. I'm delivering
I
food. You
understand that.
pulled me
I
over for
understand.
no
Listen,
reason.
I didn't know.
Step back here with us. Give us your information.
He already gave me his information.
I gave him everything
Okay,
y'all
well, let
need.
him
What
talk
else
to
do
you
you
right
need?
here,
Let
and
me
then
just
you
talk
can
to you.
go.
Okay, talk to me.
All right, talk to me back here
Why?
because I asked you to, buddy. We do not want to take you out of this car. Okay, I do not want to arrest you tonight.
You have no reason to arrest me. I have done nothing wrong.
If you don't get out of
If
the
you don't get out
vehicle,
of the car, it's obstruction charge that will be filed against you, or resisting arrest if you find it.
Now comes the important question. Do officers have the authority to ask anyone to exit their vehicle at their discretion? Well, according to established legal precedents, officers may order a driver out of a vehicle during a lawful traffic stop for officer safety, as per Pennsylvania Veers Mims, 434 U.S. 106, 1977. However, it's worth noting that the officers initiated the traffic stop solely because of an issue with one of Mr. Jordan's taglights. This minor infraction might not in itself justify the officer's immediate order for Mr. Jordan to step out of his vehicle without further explanation. In fact, as concluded in the 2015 case of Rodriguez v. United States, the Fourth Amendment prohibits police officers from prolonging a traffic stop beyond the time necessary to investigate and write a ticket for a traffic violation unless the officers have reasonable suspicion that the stopped vehicle's occupants are engaging in other crimes. So, judging by this, it could be argued that the officers may not have had reasonable suspicion.
It could be argued that the officers did not have reasonable suspicion at all. They were instead hoping to fish for something inside the vehicle that would land Mr. Jordan in trouble.
He complied with the officers,
since Mr. Jordan had no other options, he complied with the officers and stepped out of the vehicle. The officers immediately patted him down and tried to reach inside his pockets too. They justified this by stating that it was a Terry stop and that they were allowed to do this. A Terry stop allows the police to briefly detain a person based on reasonable suspicion of involvement in criminal activity. It is stated that police officers may stop a vehicle to investigate if they have an articulable reasonable suspicion that the vehicle is subject to seizure, or a person the vehicle has committed, is committing, or is about to commit a crime. So essentially, this traffic stop has gone from a taglight issue to suspecting Mr. Jordan of a crime.
Okay, I already know the ropes of all you guys, what you guys do.
No,
I don't.
Okay, I'm gonna pat you down real quick, all right?
He's gonna pass down for his safety. That's it.
This is a joke, man. I'm sitting here trying to do my job.
We understand.
What's that in your pocket? Is that just a blowtorch? Don't reach for it.
I mean, I don't know what it is, man.
You care if I get in your pocket and get it out?
What? No. What do you got your hands on me for?
Because I'm patting you down. It's called a Terry frisk. We're allowed to do that.
You're only allowed to do that if you arrest somebody.
Let's come back here.
You're not arresting me.
Come back here.
At this point, the officers finally told Mr. Jordan about their reasonable suspicion for pulling him out of his vehicle and detaining him. They claimed that they smelled an odor of marijuana coming from his vehicle, which they asserted gave them authority to search the vehicle. The legal status of using the odor of marijuana as probable cause varies by jurisdiction and can be complex. Despite changes in state laws legalizing the possession of marijuana under some circumstances, many courts have ruled that the odor of contraband can give officers probable cause to perform a search. However, allegations have been made that in some cases, officers may misuse this justification. In this incident, we cannot determine whether the officers actually smelled marijuana or not, and there is no definitive way to prove or disprove their claim.
This is a joke, man.
Sit right here so I can talk to you.
This is why people don't like the cops. You guys are harassing me because I was in the ghetto delivering food. I knew it when I seen you. I knew it. I told myself he's going to pull me over for delivering food.
The reason I'm getting you out is, like I said, I'm smelling a strong presence of marijuana.
You guys say that every time you pull somebody over. You're not gonna, I'm not giving you permission to search my car.
I don't need permission.
Yeah, you do.
No, I don't.
Yes.
Not if you smell.
You guys cannot search someone's car saying that you smell marijuana.
I can't. Okay.
Well, I'm telling you right now that you have no legal basis to search my car.
I'm going to search your vehicle, okay? And you're going to stay right here with my buddy while I search your vehicle.
This is a joke.
Okay? Am I going to find anything? Because I'm trying to work with you. I'm about to lose my patience, okay?
You are?
Yeah.
What's your badge number?
So, we don't have badge numbers. Stay here with my buddy.
What's your name?
All right? Stay with my buddy.
It's also important to note that the officers here refuse to identify themselves. Considering that the Charleston Police Department does not assign badge numbers to their officers, the only reasonable form of identification would be the officers' names, which were unfortunately not provided. Despite this, the officer proceeded to search Mr. Jordan's vehicle, spending about 5 minutes going through the car. Meanwhile, Mr. Jordan and the second officer on the scene were exchanging words.
This is harassment.
There's no harassment going on.
Yes, this is definitely harassment.
Lawful traffic stop.
He didn't make a lawful traffic stop. I break no law.
Registration light out, right? Registration light out.
I broke no
Cancel
laws
your
here.
license plate from a distance.
So every time you guys stop
They give
somebody,
you
you're gonna say you
to
smell
stop somebody.
marijuana.
And we walked up to the driver's side door, smell marijuana. That gives us probable cause to search the vehicle. may cut you a ticket. He may just let you go for nothing if we don't find out, okay? There's no harassment going on here. I'm sorry you got a bad experience with police officers.
I've had a lot of bad experiences with police. I can't stand them.
I understand that. That's not us.
You guys are harassing me for delivering food to the ghetto.
Absolutely not.
Yep, absolutely.
You're the one that's labeling as ghetto.
That up there is the ghetto.
You're the one that's labeled that label.
What would you call it?
City Park. It's Renaissance.
Why you guys always patrol it?
We don't. We run up there when we get 911 calls. You're the one that called it the ghetto. It's called Renaissance Park, Vista Apartments.
While the first officer continued to search Mr. Jordan's vehicle, a supervisor named Sergeant Van Horn arrived on the scene. Despite Mr. Jordan's concerns, Sergeant Van Horn did not intervene or investigate the situation further. When Mr. Jordan stated that he'd be suing the department, the second officer announced the department's address, implying that he was not concerned about the potential lawsuit. As this went on, another officer who was also searching inside Mr. Jordan's vehicle indicated that he had found some marijuana in the trunk. In response, Mr. Jordan claimed that the officers had planted the small amount of marijuana, asserting that it was not his. While we cannot ascertain the truth of these claims, the situation underscores the tension and mistrust between Mr. Jordan and the officers. Regardless, Mr. Jordan was asked to step back inside his vehicle, and the first officer stated that he would be giving Mr. Jordan a break by writing him a citation and letting him go home. One might wonder why the officers extended the encounter, only to ultimately issue Mr. Jordan the same ticket that could have been written at the beginning.
Cops are not very liked. So the things like this, man, harassing somebody. What did you do, plant that?
Is that all you had?
Is that what you planted? Is that what you planted on me? Just a little bit of weed?
Give him an attitude. He can take you to jail or he can cut you with a
Well, I mean, he's gonna do what he's gonna do, man. I'm not gonna beg him to do nothing. Believe me.
No, it's not
You
what
can do whatever you want to
it's
do.
our choice whether we want to charge or not.
You guys want to plant weed on me and stuff, and that's fine.
Absolutely not. But nobody's in the wrong, man. It's probably not even a car, is it?
It's my wife's, actually. I have 4 kids, actually. Yeah. I take care of 4 kids, and I don't like getting harassed. Yeah, they're mine. They're mine. I'm a good father, actually. Yeah. You probably don't have any responsibility.
Hey, buddy, go ahead and have a seat back inside. I'm gonna cut your citation and get you out of here.
Mr. Jordan was cited and allowed to leave shortly after. He has indicated that a complaint was filed against the Charleston Police Department, but no further updates have been provided. Thank you for watching US Corrupt Cops. If you found this video enlightening, please like, share, and subscribe for more stories that matter. Stay informed and stay safe.